From Just the News, Supreme Court orders New York to respond to Missouri lawsuit over Trump lawfare this week. This seems pretty big. Is this a victory for you guys?
Yeah, this is huge. I mean, the Supreme Court has taken notice of the lawsuit we filed against the state of New York. And again, you've got a rogue prosecutor and collusive judiciary in New York who have prosecuted Donald Trump under specious legal grounds. The prosecution is replete with constitutional procedural error. Ethics violations should have never happened. I've never seen such a gross miscarriage of justice, but that's what you get in New York. And at the end of the day, that hurts Missourians and every other state because we have a right to participate in a national presidential election on equal footing with every other sovereign state. And Missourians are being denied access to and being denied the ability to hear from a presidential candidate in the heat of a campaign in the most consequential national election in this country's history. And so that harms Missourians.
So you filed, I should say, on behalf of the state of Missouri, you sued New York, its original jurisdiction. So the Supreme Court is the court that hears it. We announced the news when it broke, and many people said, but wait, Supreme Court's out of session. How does this work?
Yeah, different dockets. So you've got kind of the Supreme Court's appellate review docket, and that's what mostly the Supreme Court does, is review cases that have been adjudicated at a lower court. But the Founding Fathers contemplated there would be disputes amongst the states, and they codified a method by which we could redress those grievances in Article 3, Section 2 of the United States Constitution. And it's the original action docket. And so that's separate and apart from kind of their appellate review. And so other states have sued other states before. Typically, it's about like water rights or boundaries. This is different because, again, we're suing the state of New York for hijacking this election and injecting poison into our democratic process through lawfare. But it's an original action of the Supreme Court. We filed our pleadings. The court has ordered New York to respond. They have until tomorrow to respond. We'll see what they do.
There are 3 claims you're making?
That's correct. Yeah. Number 1, First Amendment violation. The gag order that the court instituted in New York is unconstitutional. It violates President Trump's right to speak, but it violates our right to hear from him. And the important point here is like the gag orders in criminal prosecutions, there's a strong presumption against gag orders because of our First Amendment rights. But that's especially true, and those considerations are heightened when you're talking about a presidential candidate.
The front runner.
But beyond that, the gag order is supposed to protect a defendant's right to a fair trial. Well, number 1, the trial's over. Number 2, here the state, the prosecutor got the gag order. If Donald Trump wants to put himself at risk by speaking out publicly about the trial, he should be allowed to do that. And we have a right to hear from him. So that's the first claim. The second claim is that, in Missouri, we had a caucus and there were electors who were selected based on that caucus to attend the convention and cast votes for President Donald Trump to be the Republican nominee. Those electors are being denied access to a presidential candidate because anytime he's spinning in a Manhattan courtroom or potentially in a New York State penitentiary or on probation in New York, he can't be campaigning. And that harms our ability to have access to him. The third claim is under the Purcell Doctrine. So the Purcell Doctrine stands for the proposition that courts should stay out of decisions that would obfuscate or interfere with an election. And again, those considerations are heightened the closer in time you get to an election. And so the same should be true in New York. People are already asking me, constituents reach out all the time. Can Donald Trump be on the ballot? Am I going to get to vote for him? Is he going to get to come to Missouri and talk to us? Can he still serve as president if he's convicted of a felony in New York? So this New York court is violating the Purcell Doctrine by injecting that kind of level of obfuscation into the electoral process.
This is absolutely crazy because it brings up a lot of questions. Now, we know any reasonable person who reviews the criminal charges against Donald Trump in the hush money case would scratch their head and say, what?
Yeah.
None of this makes sense. And I'll break it down because I know there's people who haven't watched every show, but I'll try and make it quick. The charges against Donald Trump are for falsification of business records, but that's a misdemeanor and it's beyond its statute of limitations, meaning they can't bring the charges. What are we talking, 7 years later? They claim it's upgraded to a felony if you falsified business records in furtherance of a secondary crime. Now, they claimed that Donald Trump, the judge said to the jury, if you believe Donald Trump committed a secondary crime, it doesn't matter which one, then you can find him guilty on this one if you believe he also falsified business records. Now, correct me if I'm wrong, but how does a court, first of all, upgrade a charge with the presumption of a secondary crime that has never been adjudicated through any kind of due process means or anything?
Yeah.
The court is just decreeing the crime exists.
That's right. And 2 problems there from a constitutional standpoint. Number 1, lack of notice. 34 count indictment that, again, refers to, false business entry for this based on another crime. And you can read the indictment. It says another crime 34 times, 34 counts. That's a notice violation under the due process clause. President Trump has a right to have notice of the alleged offense. So they deprived him of due process in that regard. Jury unanimity is under the Sixth Amendment is the next problem. So when the jury goes back to deliberate and the judge says, hey, pick any old predicate offense you want, you don't have to agree. Under Ramos v. Louisiana case that was handed down by the United States Supreme Court in 2020, stands for the proposition that the Sixth Amendment right to a fair trial includes the right to jury unanimity as to every element for which the defendant is charged.
Wow.
So they violated his constitutional rights to due process, violated his First Amendment right to free speech, violated his Sixth Amendment right to jury unanimity. You look at the fact that the prosecutors were politically motivated because they campaigned on a promise to prosecute President Trump. They should have been disqualified. The judge has deep ties to the Democratic Party, also should have been disqualified. In Missouri, it's an appearance of impropriety standard. Well, here there's actual impropriety. It's not an appearance.
Not an appearance at all.
It exists. So like they should have been this is reversible error. It's an incurable impropriety. When I say that the case is an illicit witch hunt prosecution, that's what we're talking about. Is all of these problems that typically in a criminal trial, maybe you have one problem that results in what could be reversible error. But here it's like replete with reversible error.